I'm Elena, and you are watching Law and Organ. This is a dramatic reading of a contract case, Rockingham County versus Luten Bridge Company, 35th Federal, 2nd Series 301, 1929. This is the opinion of John J. Parker, Circuit Judge. This was an action at law instituted in the court below by the Luten County Bridge Company as plaintiff to recover of Rockingham County, North Carolina, an amount alleged to be due under a contract for the construction of a bridge. The county admits the execution and breach of the contract, but contends that notice of cancellation was given the bridge company before the erection of the bridge was commenced, and that it is liable only for the damages which the company would have sustained if it had abandoned construction at that time. The judge below instructed a verdict for plaintiff for the full amount of its claim. From judgment on this verdict, the county has appealed. The fact out of which the case arises, as shown by the affidavits and offers of proof appearing in the record, are as follows. On January 7th, 1924, the Board of Commissioners of Rockingham County voted to award the plaintiff a contract for the construction of the bridge in controversy. The bridge was politically controversial, and by February, the anti-bridge faction was in the majority. At a regularly advertised called meeting on February 21st, a resolution was unanimously adopted declaring that the contract for the building of the bridge was not legal and valid, and directing the clerk of the board to notify the plaintiff that it refused to recognize same as valid contract, and that the plaintiff should proceed no further thereunder. This resolution also rescinded action the board theretofore taken looking to the construction of a hard-surfaced road, in which the bridge was to be a mere connecting link. The clerk duly sent a certified copy of this resolution to the plaintiff. At the time of the passage of the resolution, very little work towards the construction of the bridge had been done, it being estimated that the total cost of labor done and material on the ground was around $1,900. But notwithstanding the repudiation of the contract by the county, the bridge company continued with the work of construction. On November 24th, 1924, the plaintiff instituted the action against Rockingham County, alleging that for work done up until November 3rd, 1924, the county was indebted in the sum of $18,301.07. As the county now admits the execution and validity of the contract and the breach on its part, the ultimate question in the case is one as to the measure of plaintiff's recovery. The court, in a lengthy discussion of North Carolina local government law, which I will spare you, concluded that the commission that canceled the bridge project was legally able to do so, but that this nevertheless was a breach of county's contract with Luten Bridge Company. Coming then to the question as to the measure of plaintiff's recovery, we do not think that after the county was given notice, while the contract was still executory, that it did not desire the bridge built and would not pay for it. Plaintiff could proceed to build it and recover the price. It is true that the county had no right to rescind the contract, and the notice given the plaintiff amounted to a breach on its part, but after plaintiff had received notice of the breach, it was its duty to do nothing to increase the damages flowing therefrom. If A enters into binding contract to build house for B, B of course has no right to rescind the contract without A's consent. But if before the house is built, he decides that he does not want it and notifies A to that effect, A has no right to proceed with building and thus pile up damages. His remedy is to treat the contract as broken when he receives the notice and sue for the recovery of damages as he may have sustained from the breach, including any profit which he would have realized upon performance, as well as any other losses which may have resulted to him. In the case at bar, the county decided not to build the road of which the bridge was to be part of, and did not build it. The bridge, built in the midst of the forest, is of no value to the county because of this change in circumstances. When, therefore, the county gave notice to the plaintiff that it would not proceed with the project, plaintiff should have desisted from the work. It had no right to pile up damages by proceeding with the erection of a useless bridge. The contrary view was expressed by Lord Cockburn in Frost versus Knight. But as pointed out by Professor Williston on Contract, Volume 3, page 2347, it is not harmony with decisions in this country. The American rule and the reasons supporting it are well stated by Professor Williston as follows. There's a line of cases running back to 1845 which holds that after an absolute repudiation or refusal to perform by one party to a contract, the other party cannot continue to perform and recover damages based on full performance. This rule is only a particular application of the general rule of damages that a plaintiff cannot hold a defendant liable for damages which need not have been incurred, or, as it is often stated, the plaintiff must, so far as he can without loss to himself, mitigate the damages caused by the defendant's wrongful act. The application of this rule to the matter in question is obvious. If a man engages to have work done and afterwards repudiates his contract before the work is begun, or when it is only partially done, it is inflicting damage on the defendant without benefit to the plaintiff to allow the latter to insist on proceeding with the contract. The work may be useless to the defendant, and yet he will be forced to pay the full contract price. On the other hand, the plaintiff is interested only in the profit he will make out of the contract. If he receives that, it is equally advantageous for him to use his time otherwise. The leading case on the subject in this country is the New York case of Clark versus Marsilia, 1 Denio, New York Superior Court, 317-1845. In that case, the defendant has employed plaintiff to paint certain pictures for him, but countermanded the order before the work had finished. Plaintiff, however, went on and completed the work and sued for the contract price. In reversing a judgment for the plaintiff, the court said the plaintiff was allowed to recover as if there had been no counter-demand of order, and in this the court erred. The defendant, by requiring the plaintiff to stop work upon the paintings, violated his contract and thereby incurred a liability to pay such damages the plaintiff should sustain. Such damages would include a recompense for the labor done and materials used, and such further sum in damages as might, upon legal principles, be assessed for the breach of the contract. But the plaintiff has no right, by obstinately persisting in the work, to make the penalty upon the defendant greater than it would otherwise have been. It follows that there was an error in directing a verdict for plaintiff for the full amount of its claim. The measure of plaintiff's damages upon its appearing that notice was duly given not to build the bridge is an amount sufficient to compensate the plaintiff for labor and materials expended and expense incurred in the part performance of contract prior to its repudiation, plus the profit which would have been realized if it had been carried out in accordance with its terms. The judgment below will accordingly be reversed and the case remanded for a new trial. Reversed.